Hello, I'm Janice Corrales from Corrales Law Group, and today we want to continue with our frequently asked questions. Today I want to answer a question that I receive about 5 times a week. It's really popular right now, particularly with the new waivers, and it's really important to get information out there because it's an area where a lot of people commit fraud, and then there's also a lot of misinformation going on with notarios or other people who aren't lawyers, and they're giving out information that could really hurt people and harm them in the end. So the question is, and it comes from parents or even the child sometimes, a person comes into my office or wherever I'm at and they say, I am not in the country legally right now, but I have a U.S. citizen child who is now 21 or about to turn 21. Can my child help me get my residency or help me adjust in some way? And the technical answer is yes, your 21-year-old child can petition for you, but whether you will be able to gain your residency is a little tricky. The most common scenario, which just you normally can't, and this is the one we see the most often, is you have a 21-year-old child who is a U.S. citizen, but you came into the country illegally, as far as you weren't admitted and you didn't have a visa, you just kind of snuck in or something of that sort, and you have no documentation here, and your child's a citizen, but 21. So the child petitions for you, but what happens is because you didn't come in with a visa and you weren't admitted, you're going to have to do your interview outside of the country. You're going to have to return to your country of origin. When you return to your country of origin, as many people know, they will then tell you that because you were in the United States for over a year without documentation or without being allowed to, you now have a 10-year bar, and you're not allowed to come back into the United States for 10 years. There is a waiver for this, as a lot of people know, and there's a provisional waiver now where you could do before you leave. But the thing about the waiver is that to get the waiver granted, what you need to prove is extreme hardship to a U.S. citizen spouse or U.S. citizen parents, in the case of a provisional. For not provisional waivers, you could do resident parents or resident spouse. But you do need a spouse or parent. So your child's suffering is not going to count for the waiver. Kind of doesn't make sense at all, but that's the way the law is right now. So your suffering to the child who's asking for you to be in the United States is not going to count. You can't say my child's going to suffer without me, who's going to take care of them, who's going to support them. Doesn't count. You could weave it into a waiver normally using a spouse or a parent, but without a spouse or a parent that qualifies you, you're not going to be able to have your waiver, and you're going to be stuck outside the country. So if you're in this situation, it's really important for you to seek a lawyer and not a notario or not a immigration assistant. You really want somebody that knows the law and can help you to make sure you don't end up in another country for 10 years, right, with no way back in. So if you don't have a U.S. citizen or permanent resident spouse or parent, and you just have a 21-year-old child, you came in without a visa, you weren't admitted, and no one has ever petitioned for you before, no, your child should not be asking for you yet because there is no waiver that you're going to be able to qualify for. And if you do have a U.S. citizen or a resident parent or spouse, you could technically have the child petition for you and use the parent's suffering or spouse's suffering to have your waiver granted, but that's not too common because usually if you have a spouse or a parent with status, they would normally be asking for you or petitioning for you, so that's not too common. Now another situation is people who came in with a visa. So let's say you came in with a visa, but you overstayed, you never left, and now you have a 21-year-old U.S. citizen child. These people, they can adjust in the country. So your child can petition for you and you can adjust. Thinking everything else is okay and you have no other issues that make you inadmissible. Another situation that is common is people who didn't come in with a visa, but they were admitted. And this means that you came into a port of entry, like let's say the Tijuana border, and you were in the back of a car, there was a lot of people in the car, and the U.S. or the officer at the border just said, go on in, and didn't ask any questions. And you were in the car, so you were technically admitted, you were inspected and admitted, but you have no proof because you don't have a stamp in your passport or a visa anywhere. This is very common also with Canada, where before they used to just wave people in without asking for a passport or anything. So if you came in this way, you technically were admitted and inspected, so you can adjust in the country, and your 21-year-old child can ask for you or petition for you, and you can adjust. The issue becomes proving that you came in through the line or through the border. So we've seen a lot of different things going on. It's a relatively new area of law, but people are doing it, and it is working. If you really came in through the border at entry point, you can adjust. Sometimes a declaration's enough. It depends on the officer that you get, really, but a declaration from you saying that, you know, you were in the back of a car at this and this time, this and this date, officer said you can come through, you came through, that might be enough. Other people who were in the car, other people around you, that could also work. We've even seen lie detector tests, people who are like, I will take a lie detector test and submit it, and that's pretty good proof too. But if you are in that situation, I do suggest you seek a lawyer just in case it gets complicated, because it can. You might get a not bad officer, but a stricter officer, or officer who has a really high burden of proof and doesn't believe you, and then you're going to have to go through different processes. So in that situation, you probably want a lawyer if you want to go that way, but it might be easier than doing the route of having to leave the country. So these are different options, but the most important thing is if you were never admitted, you don't have a U.S. citizen or a resident spouse or parent, and you only have a U.S. citizen child that's 21, you should not be applying for this right now, because there's a good chance you're going to be stuck outside of the country for 10 years. And you might not have been there for over 21 years at this point because you have a 21-year-old child, so you don't want to risk that, and you definitely want to seek legal guidance and not just rely on notarios or people who offer immigration services but aren't technically licensed to do so. If you have any questions about this or anything related to this, please feel free to call us and email us. Also, we're looking forward to the reform, which should really help this, because it really doesn't make sense that a child suffering can't be included. And we're expecting a really good reform upcoming, and we will have more videos on that as well. But if you have any questions, please just go ahead and call us or email us. Thank you.